Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. Yep, it's nice to see you all joining. Go ahead and put your questions in the comments. I have a few updates to talk about. Two of these have to do with asylum. So we had a Supreme Court decision, that's the highest court in the United States. When they come out with a decision, it is now law. And so we have a new law or a new order in regards to asylum. We also have a lower court decision, which is good news, but it is a lower court's decision. This also discussing limits on certain measures that ICE have been taking in terms of asylum. So let's start with the Supreme Court decision. So the Supreme Court has now the order that they have in their decision. What they have said is that if a federal court is going to make a decision on a past immigration court judge's decision, so it was appealed all the way up to the Supreme Court, the the federal court judge has to now defer to the decision of the judge, the immigration court judge. Why does this make a difference? It does because in the past, the federal court judge would start from scratch. They would look at everything from scratch without considering the other court's decision. However, in this case, what they've said is they now have to give deference to the immigration court judge's decision, which means now they have to actually look at what the judge has said, look at the evidence the judge decided on, and they have to give it some form of preference. And so what that means is that if a judge made a decision, it's likely that they are going to uphold that decision because they're giving it deference. They're giving it a certain level of preference. So the takeaway from this is it's now harder. You have to make sure that when you are bringing your case to the immigration court, you must bring your strongest case. That is not the time to hold back on evidence or to hold back on strategy or to hold back on effort. You must make sure that you are putting your best foot forward, because that evidence is going to, if you brought poor evidence to an immigration court judge, that judge then determined that the evidence wasn't sufficient to make a decision on the asylum in this case, then you appeal it to the BIA, for example. The BIA is already hard to get in with the BIA, but the BIA then looks at the immigration court judge's decision and says, well, that's what the judge said. There's nothing that would necessarily be outrageous in that judge's decision, so we're going to go with that. And if they then jump from the BIA to the federal court, the judge also has to do the same thing. The federal court judge has to do the same thing. So bring your A game from the start, because if you don't, then that can haunt you as you appeal your case. Usually when I am taking on an asylum case, and we have gotten approvals within the last year, but what we do best in asylum is we prepare. So we don't, it's many people start looking for lawyers, for example, for their asylum court case, and even their asylum interviews a week before the hearing. That's a no-no. That is a no-no. Why? Because when we are dealing with an individual hearing, where asylum is going to be considered, or any kind of relief for that matter, there is going to be, you have to have evidence to establish credibility. You may need to have expert witnesses present, and it takes months to look at expert witnesses, to recruit expert witnesses, to hire expert witnesses. You may have to have witnesses testify. And then in addition to that, also doing additional research to establish that, to be able to establish that credible evidence that's going to support approval. So the Supreme Court's decision is basically saying that if you don't bring the evidence at the start, it could then follow you and haunt you all the way to the federal court, if you're going to keep appealing your case all the way to the federal court. So bring your A game. Now, the other decision I would say is good news, and that is a federal court, a district judge in Massachusetts did find that ICE deporting people to third countries, not their country, people with removal orders who are sent to third countries instead of countries of their that they're originally from, is not permissible. That the ICE cannot do that without giving them proper notice and the ability to challenge their deportation to a third country. So, if you've been watching the news, you've been listening, you've been seeing that a number of people are just being picked up. If they have a removal order, they're being sent to countries that they know nothing about, that they have never went to, they've never settled in, they've never had residency in. And so the judge has found in this case that is not permissible, it's not lawful. And these individuals must be given the opportunity to have due process and to challenge that removal. Now, yes, this is great news for immigrants. However, it's important to understand that this is a district court decision, and the judge has put a pause on their order in order to allow the government to appeal his decision, which means that if the appeal court disagrees with the judge, then we could be back at square one with them finding, with ICE continuing to do third country removals. Now, it's also important to know that the Supreme Court did in an preliminary injunction. So they lifted a ban and said that the ICE can continue to send people to third countries. So this may be appealed all the way up to the Supreme Court, but based on the past decision of the Supreme Court, they may very well still allow removals to third countries. But in the meantime, this is good news. And we are seeing patterns where the federal court, they are now starting to recognize that there's a serious deprivation of due process. And so we're seeing a lot of federal courts stepping up to the plate to be able to put orders in place to protect the rights of immigrants as they fight. So this is where it's very important to not give up. Make sure you look at solutions even at the federal court level. Now, on the upside, in the law firm, as I continue to fight for my clients, fight for the ability for my clients to stay here, is that we continue to get results for our clients. We continue to get approvals. So we have gotten, even today, a work permit that's related to the T visa bona fide determination. We got this bona fide determination work permit while our client is waiting for their T visa to be approved. So this is just a reminder that there are solutions out there that you can take and you can be proactive in. You don't have to find yourself in a bad situation before you start to look at options that can get you the relief that you need to be able to stay here and to protect yourself. So always get in touch with us so that we can talk about those possible options. Now that I've said my part, I want to answer some questions. So go ahead and put your questions in the comments so that I can answer. What is the status of the paused immigration? So it has not changed. So there is pending litigation, and I'm hoping that we can see something come soon. But for now, it's still in place. What I would say is, even though they have a pause in place, it's so important to make sure that you still move forward with any kind of processes that you qualify for. Not moving forward with a process can mean that you end up foregoing the ability to pursue that process in the future. Hi, Demaine. It's nice to see you on YouTube. Been married from 2022. Haven't submitted any paperwork yet. Husband and I are separated though. So in this case, you may still have options. Now, I don't know what happened, but talk to us. Give us the specific facts, which is confidential, so we can understand your situation and be able to advise on whether you're able to pursue options on your own. There are ways to still pursue your green card, your work permit, protection here, even if you're separated from your spouse. But we have to know more to be able to confirm whether you qualify for that kind of relief. You can give us a call. Right now, we are answering calls 24/7. Right now, I am accepting appointments. So even on Saturdays, because our schedules are filled up, but we want to continue to help people as much as possible. So we even have Saturdays available now to be able to schedule time with me to talk about those potential solutions. But you have to get on it very quickly because already my schedule is filling up. So make sure you're on top of it. You can go to the link in the profile and you can go to the website. You can go ahead and submit a contact us form, or you can go ahead and call, and then we will call you back first thing in the morning. What do they mean when they said case closed even though you're paroled? So I'm not sure what case is closed. That sounds like you need to get a lot more specific. We have to understand what your circumstances are. Okay, don't have the number. Can you give it to me, please? So if you go to the videos, you will see my number on every single video. And then you can also go to the website, you'll see the number there, but I'm also gonna put it here. It's gonna be under Immigration Lawyer Sharifa. So you can go ahead and give us a call so we can talk about your options. Because there are multiple options out there. How long it took for your client to get their bona fide work permit? We already passed 14 months and still waiting for a bona fide work permit, T visa approval. So this client, it took 12 months. So it took, I believe, 10 months to get the bona fide determination, and then another 2 months to be able to get the 13 months. So 10 months to get the bona fide determination, and then 3 months to be able to get the work permit. Now keep in mind, guys, that while it is indicative that we are getting results and the people are getting protection even during these times, it really differs based on case times, and it even differs based on when you applied. Right now, they're prioritizing work permits and bona fide determinations for those who applied on or after August 24th or August 24th, I believe, 2024. So it just depends on when you applied. And also keep in mind that the bona fide determination is all discretionary. And so it means that it's when discretionary means that they can or they may or they may not. And it really is up to them to decide. But our clients have been getting it. And that means a lot because the bona fide determination alone offers protection from removal. And the work permit that comes along with it is an added plus that allows our clients to work, continue to work and gain stability and have identification. I'm from East Africa, Tanzania, one of the least of burned country. I filed for change of status through my daughter, who is a US citizen. I filed March 26, 2025. I did biometrics, but up to now, I received zero. So if you are one of the banned countries, there is a pause. So there is a pause on all benefits. So if you are in the country, it doesn't mean that they're stopping your process completely, but right now they are pausing it. So that may be why you have not received anything since then. It's been 8 months, but I'm still waiting for biometrics. So biometrics, especially, and biometrics can be all over the place, especially in regards to certain benefits. For example, the T visas. I can tell you of a situation where one of our clients was so afraid to go to the biometrics appointment. We got their appointment within 2 months of them applying, and they did not go to the biometrics because they were so afraid. Eventually, we did tell them that it is a means to an end. They have to do the biometrics to get the decision. We got another biometrics appointment 1 year later. And when our client, as soon as our client did the biometrics appointment, we got the T visa approval 1 month later. That goes, and we've seen that before with another client that they waited 10 months. The biometrics came at the 10-month mark, and then within 2 months, they got their decision. So that all goes to show that sometimes the biometrics comes later on in the process, and then the decision comes soon after. Now, I want to premise this by saying that I am speaking from experience, but it does not mean I can guarantee any results or guarantee processing times. Anybody that's telling you that they have control over processing times is a scammer, right? I can give estimates. I can have a certain idea of how things are going to go, but really and truly, each case is different. And you have to be prepared for that, especially now. So the N400, if you want to apply for citizenship, the first thing that you should do is schedule an appointment to talk about your qualifications. Then we can decide based on your particular circumstances what that cost is going to look like. Because every case is different, but we need to make sure you qualify. Can asylee with green card hold use their country of origin passport to travel to another country? So it depends. So it sounds like it says, can asylee with green card hold? So I'm thinking, can an asylee, someone who was an asylee who now has their green card, use their country of origin passport to travel to another country? It depends. I don't know, first of all, which country are you from? Is the country facing any kind of bans right now that put you at higher risk of something happening? Green card holders, on general, can travel, but you want to make sure that everything is okay in your background. Make sure that if the country you're traveling to is not a country that would raise any questions in regards to your status. And also, some countries, if you're traveling with a green card, some countries still require you to have a visa. So you would have to make sure that you're complying with the country and their requirements to enter with the proper paperwork. I'm divorced. I'm in NY, so it's 5 year rule. Yes, yeah. So if you are divorced, you got your green card through marriage, but you're divorced, then you have to wait for the 5 years to apply for citizenship. Can you still travel on a travel document with all that's going on now? And are they still being processed? So we have been getting approvals on the travel document. However, keep in mind that I am very conservative about travel. I have seen people travel on travel documents and still have problems coming back because every time you are traveling back into the country, especially now, they are going to be re-evaluating you for to decide whether they're going to admit you into the country. So we are finding that they're now asking questions about your application. They're reviewing it. They're looking at your background um, in order to determine whether they are going to give you admission. So some people have found themselves in removal proceedings, or they found themselves also being they're in removal proceedings, or they are being detained awaiting removal proceedings, or they have been denied entry into the country. So it's very important you evaluate your individual risk before deciding whether you are going to go ahead and travel. So this is where it's very important to talk to your attorney. Make sure you go over the risks that you face before moving forward. All right, put those questions in the comments. I'm here to answer these questions. Now, it's very important to always make sure you're evaluating your options and that you're welcome, Shauna, and that you make sure that you are protected in this process. I say this wholeheartedly. No process is simple right now. And that's because the nature of the game right now, the nature of how things are, they're basically tearing down the applications, they're reviewing every single thing. And so it's important to do due diligence, to have your attorney with you for you to totally understand how to approach your process and what to take with you, what to submit, what additional applications to submit in the case that you do need to seek forgiveness or waivers or any kind of relief. So it's very important. That's what we're here for. We're here to look at options, to look at solutions, and to guide our clients through the process. Really want to weigh my options because I also have a 16-year-old son here with me. So if your spouse was a US citizen, even if they're a permanent resident, you have a 16-year-old son, your 16-year-old would be able to apply as your derivative. So they would be able to apply for a green card along with you. So you're absolutely right to want to make sure you're weighing your options, especially with your child here, because your child can be a part of the process as well. So give us a call and let's talk about it. All right. I don't see any more questions, so I'm going to call it a night. But what I want to tell you is I am on here. I do lives to talk to you about options. So make sure you're following me on YouTube, Facebook, like, subscribe, hit the notification bell. That is how you're going to see when I hop on. And when I hop on, I can give you updates about what's going on, like I did today. And in following me, subscribing, you also see videos. I release many videos every day talking about various options, various updates in order to guide and empower immigrants. Should I divorce my husband in my case? This is where I say, call us, let's talk. When you are making big decisions like this, you need to make sure that you are talking to us. Now, divorce, I like to say, in the case of the kind of relief that I'm thinking about, divorcing is not necessarily required, but this is where it's important when you're talking about big decisions like this that you, before you make any decision, you get legal advice. And that's exactly what we're here to do. All right, Shauna, I'll talk to you soon. Okay. How long does it take to submit a VAWA case? So, one thing I always talk about is here at ST Law Office, we work as quickly as we can, but we're also very detail oriented. If you follow me, you know what I'm going to say next, and it's I don't run a McDonald's drive-through. The kinds of cases that we have to present solid evidence, and we have to present credible evidence. And we go through multiple levels of review because we're not rushing to file things that will end up haunting our clients in the long run. That's what has made my firm so successful and made us have so many good results for our clients. Now, we work as quickly as we can, but we never try to mess up a case or miss anything by filing anything too quickly. So it really is on a case by case basis. So, for example, if a client has additional complex issues that we need to sift through to make sure that we're presenting a solid case, we do that. We do our due diligence. Unlike people like the notarios that quickly just fill out forms, we are not form fillers. We are attorneys. I run a firm of professionals that we do these things right. So if you don't want somebody who is going to be careful, detail oriented, and to present a solid case, don't call us, right? And I'm pretty sure everybody wants to make sure that they have a solid case because that's what's going to get you success in your process. All right. Have a great night, everybody. I will talk to you soon. Bye bye.